Good day, everyone. You are welcome to another episode of my law class at Abdullahi Legal Academy. My name is Abdullahi Adebayo Abdulrauf. On the episode of my law class today, I shall be explaining the features of law. The features of law can also be known as the characteristic of law or the attributes of law. I've explained the meaning of law in the previous lesson. If you have not yet watched the previous lesson, I will hold you to firstly go and watch the previous lesson before you can continue watching this one, because they go after one another and you can't jump the gun. You must firstly watch the meaning of law before you can understand the features of law. However, I will be reading from my notebook here, and at the same time, I will be showing the illustration on my chalkboard so that you will have the full hint and full gist of what I'm actually talking about. When we are talking about the features or the attributes or the characteristics of law, we are talking about all those things that are specific and peculiar to laws, that which if we find it in anything, we can quickly and immediately reject such a thing as law. And because of many confusion that arise from the definitions of law, if you have watched the previous lesson, I noted at the end of the lesson that a meaning or a definition of law will require us to need another definition. And because of the confusion that arises from various definitions of law, it leads us to check into those attributes that we may see in any rule that will make us to reject such a rule as a law. And because of this, we are actually talking about the attributes of law here. And at the end of this lesson, you should be able to identify some of the attributes that are specifically and specially attributed to law. Some of the attributes of law are law as a body of rules, law as coercive elements, the law is dynamic in nature, the law has territorial limitation, the law is man-made, it is defined in nature, and it is objective. Some of these attributes are what we shall be explaining further in this lesson. Now, let's start to be taking all these attributes one after the other. Talking about the law as a body of rules. Law contains various rules that affect human endeavors, from marriage to divorce, custody of children, business transaction, employer-employee relationship, criminal justice, education, transportation, interpersonal relationship, property acquisition, fundamental human rights, governance, rule of law as contained in the Constitution, legislation, judicial precedents, and customary laws. What I'm actually talking about here is that we're talking about the law as a body of rules. We are talking about those things that have been said by the authority that has the power to do so. The law is that prescription that has been prescribed by the authority that so have the authority to do so. And we're talking about this law as a body of rules. It means the generality of those things that have been said, that have been prescribed, those things that has been told to us that we should do or we should not do. And all these things, it revolves around our personal relationship with one another. It talks about marriage. Under marriage, it will be talking about whom to marry, who not to marry. It talks about divorce. It talks about custody of children in case of dissolution of marriage. It talks about interpersonal relationship. It talks about employer-employee relationship. What are the rights of the employer? What are the rights of the employees? It talks about many things. And this is what we call the body of rules, because it contains many things that affect human endeavors. And these rules are embedded in Constitution, the legislation, and judicial precedent as it has been provided for us. Let's take the Constitution for instance. If you check into the Constitution, there are many things that have been stated. The rule of law in Nigeria, the separation of power, the independence of the judiciary, how will a president be elected, how can he be removed from the office, how will a governor be elected, how may he be removed from the office, how are we going to be appointed the judges at our various courts, the power given to the legislators to make so much legislation that affect human endeavors, and all these kind of things. This is what we mean if you say the law is a body of rules. Let's go to the second attribute. The second attribute is that the law has an element of coercion. Under the element of coercion, once a law is made, it is followed by enforcement. This forces every individual or organization on which the law is made to strictly abide by its provision. The break of such law attracts penalty. What I'm actually talking about here is that once a law has been made, it has coercive element. It is mandatory on everybody in a society that which such a law is made. Let's take for instance now, it is a law in Nigeria that criminalizes the offense of obtaining by false pretense. You must not do fraud. That is yahoo yahoo. You must not do yahoo yahoo. You must not do fraud. That is the law. And the element of coercion in that law is that anybody that dares to go against that law, the punishment has been provided for. If we check section 419 of the Criminal Code Act, it provides punishment for a person that dares to go against the provision of the laid down rule, the laid down law that has been embedded under section 419 of the Criminal Code Act. Let's go further. The fear of penalty grips anyone which the law is binding upon, and they have no choice than to obey it. Element of coercion that is in law. It is because there is penalty that follows any kind of contravention that anybody may emit at any point in time against the laid down rule, against the law of the land. Because of the penalty that may befall anybody that goes against this law, everybody is mandated, everybody is under compulsion to follow and obey this law. Because of what? Because it has the element of coercion. And the law does not avail excuse to anyone who commits an offense because of ignorance. Ignorantia juris non excusat. Ignorance of the law is not an excuse. If a person should go against any provision of the laid down rule, the law, the person will not have the excuse that it is because he doesn't know that this thing is illegal or this thing does not conform with the provision of the law. That is the reason why he did it. No, the law does not want to hear that. This is the essence of the maxim that I provided. Ignorantia juris non excusat. Ignorance of the law is not an excuse. It may also be said as ignorantia juris ahud excusat, or we say ignorantia juris neminem excusat. It is all the same thing. It means that ignorance of the law is not an excuse. Because of the element of coercion in law, if anybody goes against the provision of this law, he must be punished. This principle can also be obtained under section 22 of the Criminal Code Act, and at the same time, the case of Nwosu for the state 2004. Another element, or I say the third element in my notebook here, is that the law is dynamic. The law is dynamic. As man changes in a social, political, and economic endeavor day by day, so does the law that regulates its affairs changes. As human being changes in their endeavors day by day, so does the law changes too. Some years ago, there are some things that were not in existence that are in existence now. And there must be law that will be guiding all these kind of things. Let's take, for instance, 20 or 30 years ago, there were no cyber fraud as it is here today. But just of recent, a law has just been enacted to criminalize some cyber activities. It is called cybercrime law. 20, 30 years ago, there was nothing like this. But as I'm talking to you today, the law is in existence. This is a kind of dynamism in law. Human being also changes from one stage to another. According to Section 30 of the Criminal Code Act, if a child of under 7 years old does any criminal action in Nigeria, he won't be punished for it. But if it is the case of a child of under 12 years old, the case is different. Because if a child of 12 years old should do something, and it could be proven that at the time that he was doing it, he knew that that thing that he was doing was not lawful, was not legal, he will be punished for it. That is the kind of dynamism in law too. And if it's a child that is even more than that in age, let's say like a child of 18 years old, 20 years old and above, their own case is quite similar, because the principle of ignorantia juris non excusat will be applied on such a person. And because of this, he will be accountable for anything that he does wrong. He will be accountable for anything that he does wrong. And this is the kind of dynamism in law that I'm actually talking about. So let's go back to my note here. Before 1677 in England, where we inherited our English common law principles, there was no law that mandated that buying and selling of lands should be reduced into writing under a document called deed. Immediately after the enactment of the Statute of Frauds, 1677, the position changed, and the provision of that law was being abided. What I'm actually talking about the law in Nigeria, when we move further and we are talking about the sources of law in Nigeria, we'll be talking about what is called the received English law. The received English law talks about the law that we inherited from the colonial masters that colonized Nigeria. Before 1677 in England, if anybody wants to buy or sell a land or a landed property, they don't need to write it in any document. You just have to do a kind of mutual compensation and mutual transaction within each other. You pay your money, you accept his cash, and the transaction will be done. But immediately after this legislation was enacted in England in 1677, it made it mandatory for a person that wants to buy a land or that wants to sell a land to put that transaction, to put that agreement, to put that conduct that they want to do among themselves into writing. It must be in writing. If it is in writing, if any dispute later arise from it, the common law court will give such party that has been wronged the audience to hear the matter. But if it wasn't written under a document called deed, the common law court will never entertain such a matter because of what? Because it doesn't go in line with what has been prescribed from the law. This is one of the kind of dynamism that we see under the law. Before there was nothing like writing, but after 1677, it was mandated upon them to be writing such kind of agreement into a document called deed. Let's go further. The customary law of Inuit community in Nigeria was that a female child does not have right to inherit her late father. But the position changed in the case of Mojeku versus Mojeku. The position of law in Inuit community and some part of the communities in Nigeria before 1997 was that a female child will not have right to inherit her late father. But in 1997, the position changed that no, the principle that a child that is female will not be entitled to inherit from her father's property is not in line, is antithetical, and it is repugnant to what is called good conscience, fairness, equity, and natural justice. And because of this, the principle was abolished. Now, see, before 1997, there was something like that. But after 1997, there was no more anything like that. This is a kind of the dynamism that we have in law. Sometimes something may be applicable and immediately, sometimes after, the thing may not be applicable anymore. A law may be applicable in the morning and in the afternoon, it may change. Let's go further to have this lesson as interesting as it is. The position of law as regards the correction or change of name used to be swearing of affidavits and publication on a newspaper. It has been changed to date poll and publication of name on the official gazette at the Nigerian Civil Registry by the Supreme Court of Nigeria in the case of PDP versus Dege Eremihenyo in 2021. Before 2021, if you want to change your name or you want to correct your name, they will ask you to go to the court to go and swear affidavit. And after you swear affidavit, you now go to a newspaper and publish that new name on a newspaper. And after that has been done, you have done what is necessary. Before 2021, that was the position. But immediately in 2021 and subsequently after 2021, the position has now changed. So now, in this 2023 that we have, after 2021, if you want to change your name now, you cannot go to the court to swear affidavit alone. No, you will have to go and meet a legal practitioner to prepare a document called deed poll for you. After a document has been prepared for you and it has been executed in your name, you will now advance to Nigeria Civil Registry to do what? To publish that name in an official gazette. That is what is recognized by the law now. This nature of dynamism makes law to be complex as one cannot know all the law. As such, may not be aware that the position of a law has changed. Even though this is a kind of interesting aspect of the attribute of law, but this is a kind of a factor that makes law to be complex. It makes law to be complex because a person cannot know all the laws that are applicable to even himself or in his community. And this law that you cannot know everything is even changing from time to time. How are we going to do about it? This is one of the factors that make law to be complex anyway. Another attribute of law is that the law has territorial limitation. A law that is applicable in a certain territory may not be applicable in another territory. For example, abortion is legally allowed in some countries of the world like Cuba, Ireland, Australia, France, Netherlands, and Canada. While in Nigeria, whoever administers any force or drug on herself to procure miscarriage, that is abortion, will be liable to 7 years imprisonment. Look at this, for example. The law is territorial limited in the sense that what is applicable in Nigeria may not be applicable in Ghana. The law that is applicable in Ghana may not be applicable in Sierra Leone. The law that is applicable in Sierra Leone may not be applicable in the US. And even the law that is applicable in the US may not be applicable in the UK. And that means that the law that we are using here in Nigeria, we can't force it on the people that are in Ghana or in Togo. The people of the Togo have their own law. The people of Nigeria also have their own law. And the people of UK have their own law. The people of US also have their own law. That is one of the attributes of law. Now, we're talking about the issue of abortion here. There are some countries of the world where abortion is legalized. It is backed by the force of law. If you have pregnancy and you feel like you don't want to give birth to this child, you can go for abortion and you are allowed by the law to do it. But in Nigeria, if a person administers any force that may lead to miscarriage, such a person is playing with 7 years imprisonment. This is obtainable under Section 229 of the Criminal Code Act. More so, within Nigeria, the codification of criminal offenses that is applicable in the southern part of Nigeria is different from the one that is enforced in the northern part of Nigeria. That is why adultery and drinking of alcohol are criminal offenses in the northern part of Nigeria and not an offense in southern part of Nigeria. Even in Nigeria, the law has a territorial limitation because the criminal administration of law in Nigeria that we are using are two qualifications. We have the one that is applicable to the southern part of Nigeria, that is Criminal Code Act, and the one that is applicable to the northern part of Nigeria, that is Penal Code Act. And this is why in the southern part of Nigeria, if a person does adultery, it is a way of life there. It is not a crime for a person to commit adultery there. If you can drink alcohol from this time till any time that you like, in the southern part of Nigeria, anywhere in the southern part of Nigeria, you don't have any criminal liability. You won't be punished for it. But in the northern part of Nigeria, if you check into Section 378 up to Section 388 of the Penal Code Act, the offense of adultery is a serious offense, punishable with imprisonment in the northern part of Nigeria. So if a person commits adultery in the northern part of Nigeria, he will be criminally prosecuted for it. But in the southern part of Nigeria, there's something like that. And the same thing goes with alcohol. Under Section 401 to 404 of the Penal Code Act, if a person is caught drinking alcohol, the person will be criminally prosecuted and sentenced to imprisonment. But in the southern part of Nigeria, there is nothing like that. You can see how territorial the law can be. A law is applicable to one side of Nigeria, another law is applicable to another side of Nigeria. And that is one of the territorial limitations that the law is. So you can't say because you are a northern man that you are in the southern part of Nigeria and you commit an adultery and that you will be punished. No. And you can't say you are a southern man and you go to the northern part of the country and you start committing adultery or you start drinking alcohol. If you are caught, you will be punished. That is how the law operates, especially in Nigeria. Another attribute, another characteristic, another feature of law is that the law is man-made. Law is made by men in a particular society to govern their affairs and regulate their dealings with one another. The creation of such law is influenced by the predominant custom, religion, economic thought, and political view of those that live in such society. We're talking about law as a man-made attribute, is that the law can be made by men. And this law will be governing their affairs, their endeavors, their interpersonal relationships, and their transactions in such a community. When this kind of law is being made by men, it is being influenced by their culture, by their religion, or by their political and economic thoughts in such a society. Why is the 1999 Constitution made in Nigeria? And what are those factors that influenced the making of the 1999 Constitution in Nigeria? Was that the draftsmen of the Constitution look into our culture, they look into our political thoughts, they look into our economic thoughts, they look into our social thoughts. And at the end of the day, they were able to arrive at what is inside our constitution today. Example of man-made law in Nigeria is the 1990 Constitution I've said earlier, the Criminal Code Act, the Penal Code Act, etc. All these laws are what is called the man-made law in Nigeria. There are some other laws that are made by men in Nigeria, by the legislatures. some laws like Anti-Torture Act, Cybercrime Act, Anti-Torture Act, Violence Against Person Prohibition Act, Cybercrime Act, Anti-Terrorism Act, so many other laws that have been enacted by the legislatures. All the legislators in the House, they are all men, and they are those that are making law for us. Another attribute of law is that the law is defined in nature. There are some aspects of law that are God-made. Let's go into my notes. This attribute of law is in contrast with man-made attribute of law. Approaching the features of law with this quality provides that law is made by God. Such examples of defined law can be found in religious scriptures like Quran or Bible. The main issue with this feature is that the adherents of another religion find a law that emanates from a religion other than their own as one that is not enforceable on them. We're talking about the attribute of law as one that is made by God. It is in direct contrast with the one that I explained earlier. That is man-made attribute of law. Because if you say that law is made by God, it means that the law was not made by men. And an example of those laws that are made by God is that of what we can find in religious scriptures like Bible or Quran. For example, now we call the law of Moses. Under the law of Moses, if you check into Exodus chapter 20, verse 13, it says that thou shalt not kill. And even if you check into the Quran, Quran chapter 5, verse 32, it also prohibits us from killing. These are laws, and these laws are made by God. Even though we may also find some similar provisions from the laws that are made by men. Because if you check into section 319 of the Criminal Code Act and section 291 of the Penal Code Act, it also criminalizes the offense of killing another person, and it even provide punishment for a person that kills another person. But the main issue that we may have in this attribute of law is that the adherent of a religion, they say that this law is not binding on him because he is not an adherent of that religion. Let's say, for instance, now a Christian may say that the provision of the Quran is not binding on him because of what? Because he's not a Muslim. And the same thing is applicable to the Muslim too. They may say that the provision of the Bible is not applicable to them because they are not Christians. Even though the Sharia Court of Appeal was created under Section 6 of Section 5 of the Constitution, it only have jurisdiction on the Muslims. No other religious adherents will be bound by the decision of that court unless such a person gives a written consent conceding to the decision of this court in its matter. This means that even though the Sharia court was created by the Constitution, but there are some exceptions to those people that may take their matter in front of that court. If a person is not a Muslim, the decision of the Sharia court is not binding upon him unless the person has given a written consent conceding to the jurisdiction of Sharia court that whatever is it that is the outcome of his matter in this court, he accepts it. This is even according to section 5 of the Sharia court law. So this is one of the factors that may impede this attribute. Another attribute that is last on my notebook here is that the law is objective. The question of what a person thinks the law ought to be is not welcome in law. Once the text of the law has been provided, there is no consideration for sentiment. No excuse is available for its contravention unless there is a justification provided for it under the law. The text of the law is taken as it is. The law binds and applies. It falls on whoever, whenever. It means that whenever you are approaching the law, your own thinking, your own speculations is not welcome. Whatever the law says, so be it. Ita lex scripta ext. As the law is written, so must it be followed. If the law says it is A, that means it is A. Till eternity, it will be A. There is nothing that you can say that will change that thing to be. That is what is called the objectivity attribute of law, because you don't approach the law with your own sentiment. You approach the law as it is. Whatever the law provides, so be it. For example, in Nigeria, the president has the power to appoint the chief justice, but he does not have the power to remove him. Take note of this. He has the power to appoint him, but he does not have the right to what? To remove him from office. Because of what? Because it is the law. The CJN, that is the Chief Justice of Nigeria, cannot be removed from office unless the 2/3 majority of the members of the House of Senate support the motion. Unless and only unless the 2/3 of the House of Senate support the motion that let's remove the Chief Justice of Nigeria. This is what is provided under Section 292, Section 1 of the 1989 Constitution. You cannot say because you are the one that appoints him and you are the president and you have the right to remove him. No, you can't remove him unless the Senate consent to it by what? By 2/3 majority vote. If that condition has not been met, either the president likes it or not, he has to endure and tolerate the CJN until the expiration of his tenure or the CJN retires or resigns. If if the president does not like the CJN after he has appointed them in this office, and the 2/3 majority of the Senate has not been passed against the CJN, it means that the president has to be on his own side and has to endure the CJN until the time he retires from the office, or he is dead, or maybe the time when he resigns. That's one of the objectives of the law. You can't say because you think that something should be and that thing will be. If you think that something should be and that thing is in conformity with the provision of the law, so be it, it will be. But if you think something should be and that thing is not in conformity with the provision of the law, it will never be. It will never be. We won't even accept it from you. The law won't even accept it from you. And even if you do it, it will be like you are putting something on nothing and you are expecting it to stand, which will never come into existence. Also, an action that is not an offense provided in a written law cannot be taken for an offense, no matter how influential the patient is after the commission of an action. If such action is not a crime, it can never get punished for it under the law. If you think that a patient has done something and maybe the person has infuriated you and you are angry, whatever how angry you are, if that thing is not a crime under the law, he won't be punished for it. Insult, according to some extent, is not a crime under the law. But if a person insults you now and it pains you very well, you can't do anything for that person. In as much as the person is not defaming you or is not lying against you. But if it is just to insult you, you don't have anything you can do because insult is not under the criminal code or under the penal code or under any relevant law. And this brought us to the end of this class. I am very grateful that you watched this lesson from the beginning to the end. Do not forget to share, like, and comment on this video. And also, if this is your first time on this channel, I will urge you to subscribe to this channel and press the notification button, and also like and follow us on our Facebook page with our username, which is Abdullahi Legal Academy. And also, you can text us on WhatsApp with the phone number that is showing now on your screen. Till another time that you and I shall be meeting here, when we shall be discussing some another points of law, I wish you a wonderful legal day ahead.